Habeas corpus in immigration law. When your loved one is in custody. Do you have a non-citizen loved one who is currently in custody or detention with the immigration authorities? Are you worried about their safety? Do you want to help them get released? If so, this video is for you. I'm Daniel Malakauskas of Malakauskas Law, and today we'll be going over habeas corpus in the immigration law setting. The writ of habeas corpus is not just for criminal activity, but it is for all illegal confinements. So let's begin. First off, what is habeas corpus? Habeas corpus frees an individual from wrongful detention, confinement, or incarceration. It is a legal writ that commands the wrongfully confined or detained person to be let free. Historically, when people were accused of certain crimes, they would be detained or confined. In order to ensure that it was justified when a person was detained or confined, certain criminal procedures were created. The criminal procedures were designed to separate those persons who were justifiably detained from those people that should not be detained or that should be released. Nevertheless, government authorities often ignored criminal procedures and illegally detained or confined individuals and persons. Since criminal law procedures were largely ignored and inadequate to challenge wrongful detentions and confinements, habeas corpus was created. Habeas corpus was historically a civil lawsuit against the authorities who administered the criminal justice system. It was a lawsuit that occurred outside of the criminal justice system, since the criminal justice system was not following their own procedures. Basically, you couldn't trust the authorities running the system. It was a way to bypass the illegal acts of the criminal justice authorities. And through time, habeas corpus developed into the system we have today, a system that challenges both wrongful criminal confinements and detentions, as well as wrongful civil confinements and detentions. How does habeas corpus apply to immigration law? Or what is habeas corpus exactly in immigration law? Habeas corpus in immigration law concerns challenging detentions and confinements of non-citizens. A detention or confinement can be challenged if it is illegal. Although there are many ways a detention or confinement may be illegal, it is common for a detention or confinement to be challenged when either the proper procedures were not followed prior to the detention or confinement, or when immigration authorities failed to follow post-detention or confinement procedures that would have actually allowed the release of the non-citizen. There are numerous theories to challenge detention or confinement on both substantive and procedural due process grounds, as well as statutory grounds. In addition to challenging the legality of detention or confinement itself, habeas corpus also challenges the actual conditions of confinement. Although the conditions of confinement are evaluated on a very fact-specific, case-by-case basis, when reviewing the conditions of the confinement, the court often relies upon theories germinating from the Eighth Amendment. So, what are the benefits of habeas corpus in immigration cases? Habeas corpus in immigration may benefit you or your family member in two main ways. The first and most important is that habeas corpus can force the immigration authorities to release the non-citizen from custody. Releasing the non-citizen from custody allows the person to reunite with their family and their friends. In addition, it allows the non-citizen to properly represent themselves or assist their attorney in any other legal matters that may be pending. The second way habeas corpus may benefit you or your family members is by preventing immigration authorities from transferring you to other facilities or your loved one to other facilities. Immigration authorities may illegally transfer non-citizens between various facilities. This removes the non-citizen from proximity to their family or their support system, and that makes legal representation way harder. Having a non-citizen stay in one facility allows the non-citizen to be closer to their family member and makes assisting them in legal matters so much easier. So what is the process for habeas corpus in immigration law? The process for habeas corpus in immigration law generally follows these steps. First, gathering the evidence. Second, filing the petition and any supplemental motions. Third, serving the petition. Fourth, reviewing any responses. Fifth, filing the traverse. And finally, attending any necessary hearings inside court. When you file your petition for habeas corpus, you first need to gather all the evidence. This includes any statements, any records, or any other evidence that supports your claims. You need to compile the evidence into declarations and exhibits to submit to the court. After conducting the background investigation, you must then file the petition. The petition consists of statement of facts that support your habeas corpus petition and also states the relief that you actually seek. Along with your petition, you have to file a memorandum. The memorandum explains the law and how the facts stated in your petition support the claims for your habeas corpus. In certain circumstances, you may also want to file a temporary restraining order or an application for an order to show cause. After you file your petition and the supporting documentation or the supplemental motions, you must serve the petition. Often you will serve the petition on multiple government officials. Failing to serve the proper official will result in your petition either being denied or can also cause it to be delayed. After you serve your petition on the proper government officials, immigration authorities will file their response to your petition. They will either file a motion to dismiss your petition or a motion for summary judgment, or most likely they'll file something called a return. A return is a response to your petition that allows immigration authorities to provide evidence as well as legal arguments that counter your petition. Should they file a return, it is advisable that you file something called a traverse. A traverse is a reply to the return that was filed by the immigration authorities. It is your chance to contradict what the immigration authorities have asserted in their return. After both sides file their documents, the court will either decide the petition based upon the papers submitted, or the court may schedule an actual hearing. Should there be a hearing, you will be required to attend the court and argue your case in front of a federal judge. You may also be required to testify at the hearing and to present your evidence. What are common problems with habeas corpus in immigration law? Common problems with habeas corpus petitions in immigration law are: first, authorities moving the non-citizen to various locations to make litigation difficult. Second, stalling the process to prevent the release of the non-citizen. And third, finally, raising numerous defenses that must be overcome. If an immigration authority has illegally detained you or your loved one, then chances are they will continue to disrespect the law. Immigration authorities will sometimes move a non-citizen in custody from one location to the next location. This makes tracking the non-citizen extremely difficult. Moving the non-citizen around breaks up ties to their family members, their support systems, and even makes representing them in litigation more difficult. In addition, once the petition is filed, the authorities will often try to stall the petition process. They will attempt to convince the judge to extend deadlines or cause unnecessary delays in rulings. Finally, authorities will also fight the habeas corpus petition through various legal arguments. These arguments will have to be defeated one by one. For immigration purposes, is habeas corpus based upon state or federal law? Habeas corpus for immigration purposes is almost always based upon federal law. Although the right to habeas corpus can be found in both federal and state law, federal and state constitutions, since immigration law and enforcement legally falls under federal jurisdiction, the majority of habeas corpus petitions will be based upon federal law. What federal law applies to habeas corpus for immigration detentions? The right to file a habeas corpus petition for immigration detentions or confinements is codified in Federal Statute 28 U.S.C. 2241. This law codifies all civil habeas corpus petitions for federal court. The right to file habeas corpus petitions is also found in the United States Constitution itself, under what's known as the Suspension Clause of the U.S. Constitution, which protects the privilege of the writ of habeas corpus. However, as a practical matter, 28 U.S.C. 2241 is the codified mechanism for bringing habeas corpus claims, and it is the preferred method to bring habeas corpus claims in most situations. So how effective is habeas corpus in immigration law? In immigration law, a well-drafted habeas corpus petition based upon solid legal authority and reasoning is highly effective at getting that person released from custody. When a habeas corpus petition is granted, a federal judge orders that the person must be released. The federal judge doesn't ask, the federal judge doesn't recommend, rather, the judge makes a binding order that must be followed. So how long does habeas corpus take in an immigration case? Although each case is different and each case has different facts and circumstances that may change how long your loved one is in custody and how long it takes for your loved one to be released, in practice, your loved one could be released in as little as 2 to 3 weeks. Thank you. If you liked this video, please like or subscribe. If you have any questions, please feel free to comment below. Once again, I'm Daniel Malakauskas of Malakauskas Law. Thank you.